Elon Musk is being sued for $258 billion over Dogecoin, a joke cryptocurrency. That's more money than he has, and he's the world's richest man. In this video, I'll explain what the lawsuit is about and whether Elon is probably going to lose his entire fortune or not in this lawsuit. But first, let me introduce myself. My name is Dennis. I'm a lawyer and a software engineer, and I make videos about the intersection of technology and the law. Okay, back to the case. In this case, Elon, SpaceX, the Boring Company, Tesla, probably a few others are being sued in New York's Southern District in federal court for manipulating the price of Dogecoin. This is a class action suit, and the named member of the class is someone named Keith Johnson, who lost money trading Dogecoin. And he would like others to join the class. So if you would like to join the class, here's the email address on screen. According to the motion to dismiss by Elon's lawyers, no law firms or plaintiffs have joined this class. So you might be the first. Before I break down the case, let's look at plaintiff's counsel. He's had quite the career. Starting with, he claims to have defeated Star Wars creator George Lucas on behalf of a client who created an animated pornographic film called Starballs that George Lucas sought to prevent from being distributed. He says he won that case. This film seems to exist. The images I found online were pretty disturbing. The plaintiff's counsel claims to be the first litigant to prevail in New York Supreme Court in 9/11 litigation, which would be more believable if he gave any evidence for that. I don't know what that is about. He claims to have invented the pre-sexual agreement, which was parodied on Chappelle's show. Here's a few screenshots from that sketch. Plaintiff's attorney filed a class action against bars and restaurants in New York City for including the tip in the bill. He claims that this stopped businesses from continuing the practice, which is surprising because the case was dismissed. And that would be news to me. I've seen this happen in the meantime since this case was dismissed. In another class action, he filed a class action against Match.com on behalf of models whose photos were used in fake profiles, saying that that was copyright infringement and they should get $1.5 billion because Match.com could easily use their technology to detect when identical photos were used on multiple profiles. That class action was dismissed as well. So the reason I'm telling you all this, besides the fact that it's just amusing, is that this attorney has a history of filing class actions that get dismissed later on. So let's get into the complaint. A complaint is a special document that you file with the court. This is how you initiate a lawsuit, and plaintiff's attorney in this case has submitted a very entertaining complaint. A complaint is supposed to contain claims and list the elements of the claim and then describe facts or analysis about why the elements of the claim are fulfilled. So this complaint tells a lot of funny stories, a lot of great anecdotes about times that Elon posted a funny tweet about Dogecoin, times he went on SNL, people joking about Elon being the CEO of Dogecoin. It talks about things that Jim Cramer said on his TV show about Dogecoin. Unfortunately, for this lawsuit, telling funny stories is not going to help you win a case. Unlike on YouTube, telling funny stories is not the point. So plaintiff here asked for $86 billion. How did they arrive at that number? They took the market cap of Dogecoin, the value of all the Dogecoin in the world at its peak, and then subtracted the value if you had held it all the way down. So this is on behalf of a group of people who bought, and theoretical people who bought Dogecoin at the peak and held it all the way down, and it's all of them. And then because for technical reasons in a case like this, you can triple damages. So I'm not going to break down every single claim because let's just do one and you can see how this complaint looks. So one of the One of the claims is called civil RICO gambling. So, in case you never watched The Sopranos, RICO is a federal law that was passed in 1970 in the US to try to take down the mafia. It's really complex, but the one sentence summary of RICO is that if you are a member of a corrupt organization, then you are responsible not just for your own actions, but the actions of other people in the organization. You're responsible for the actions of the organization as a whole. So this has been used to prosecute mafia families, drug cartels, street gangs, and in 1984 it was used to prosecute the Key West Police Department, but that's another story. So RICO is about racketeering, and there's a few different crimes that qualify as racketeering. One of them is gambling. And stick with me here. If you commit the crime, if you are offering gambling services illegally as part of a corrupt organization, so you commit that crime, you are guilty of the criminal part of RICO and the civil part of RICO. So if you want to win a civil RICO claim, you have to prove that someone committed a crime, and that is what plaintiff is doing here. They're trying to prove that Elon offered gambling services. So you might be wondering, what is he talking about? So let's see if the standard here is a preponderance of the evidence. So let's see if plaintiff can show that Elon was offering gambling services. The complaint doesn't explain how. So in this section of the complaint, we have 6 quotes from people like the creator of Dogecoin, various commentators, Jim Cramer saying that trading crypto is like gambling, or trading Dogecoin is gambling, those kind of quotes. But that doesn't really matter that someone said something on TV. And then the complaint says, and I quote, "Since the trading of defendant's Dogecoin cryptocurrency constitutes a gambling enterprise." So this sentence simply states a conclusion. This is what lawyers call a conclusory statement. So you could say anything you want in a complaint, but you need to provide evidence, and the complaint doesn't do that. There's another amusing part of this complaint that says, "Since plaintiff and the class were not advised that the trading of Dogecoin was nothing more than a gambling enterprise, plaintiff and the class demand the return of all wagers lost trading Dogecoin." But this is after the 6 quotes from various celebrities saying Dogecoin was gambling, and those quotes happened before Dogecoin hit bottom. So I don't even think that part of the complaint is true. That's just a little joke. So Elon's lawyers responded to this complaint. He has really strong lawyers. He has partners from the law firm Quinn Emanuel, which is one of the biggest, most respected law firms in the world. He also has in-house counsel at Tesla. The funniest part of their response is called a motion to dismiss. And when your client was accused of something, you go through the claims of what they were accused of, you go through the elements of the claims, and you say, oh, I don't agree with these facts, or as a matter of law, it wouldn't matter even if my client did what you say they did. So in this case, some of the accusations in the complaint are so vague that the defense lawyers had to say, we're not sure what Elon is being accused of. We think it's this. If it is, here's the elements of that thing. And here's why that element isn't met here. So, for example, Elon was accused of securities fraud in the complaint. And to be guilty of securities fraud, you need something called scienter. Scienter is a state of mind where someone intends to defraud or do something bad to someone. But the word scienter doesn't appear in the complaint. So, like, that element of securities fraud is not even discussed. So the complaint kind of falls flat on its face. It doesn't even list the things that it's supposed to list, much less meet the standard that it would need to meet. So what happens next in the case? We're in the Southern District of New York. The judge is Alvin K. Hellerstein, very experienced judge. And we're waiting for him to rule on this motion to dismiss. In the meantime, at any time, parties can settle. So will they settle? This is very speculative, but the reason people file class actions like this is they want the other party to settle because it'll be cheaper than paying the lawyers. Lawyers at Quinn Emanuel make over $1,000 an hour. So you can see how it would add up fast defending a case like this. And if the other side says we'll settle for, $50,000 or something, then that could actually be cheaper for you than fighting the case. Obviously, it's bad for this to be possible, for basically rich people to be able to be shaken down because lawyers are so expensive, because it's very expensive to have a trial and have a lawsuit. So the good thing for Elon to do, if he really isn't guilty, would be to fight and win, because then plaintiff would get nothing and have wasted their time, even though it would cost a lot in legal fees to do that. And Elon has done this kind of thing before, to prove a point. If they don't settle, we need to wait for the judge to respond to the motion, and he could dismiss all of the claims. If he lets any of them stay alive, then the trial will continue on the claims that remain. So that's the end of my analysis of the Dogecoin class action against Elon. If you know of any other legal matters that you would like to hear me break down, leave a comment, send me a DM. Thanks for watching, and if you like this video, please click subscribe. Bye.